Hello, everybody. My name is Juan Carlos Brando, and I'm so happy to be with you today. This time, where we are talking about immigration matters, and everything is changing every single day. So, we are excited that we can get connected to you and that we can inform everybody about what's going on with immigration. So, thank you very much for having us today. Today, we are going to be talking with Mr. Francis Fonsang, who is one of the attorneys that work and that is actually a partner in the law firm of Margaret W. Wong and Associates. So today we are going to have a good time. We are going to have a great time, and we will be able to discuss some topics about the immigration matters that are going on right now. So thank you very much, Mr. Francis. And how are you doing today?
I'm good. I'm glad to be here.
Thank you, thank you. So, well, just reminding that we have several offices in the United States, in Atlanta, in Cleveland, Chicago, um, Columbus, Memphis, Nashville, New York, Raleigh, North Carolina, and many other cities in the United States. Uh, and this is the what is important. The immigration law is a national law, it's federal law. Then we can take care of any case in any city that you are at. So the first question today, Mr. Fonsang, is uh, what is going on with these new decisions that we had a few weeks ago, and particularly in the DACA decision? What can we what do we need to know about DACA?
Well, you might have heard the Supreme Court of the United States came back and said that the administration cannot just cancel the DACA program the way that they did. So, what this means is that if you have DACA right now, you can continue to renew your DACA status. That means you can renew the DACA application and continue to receive your EAD or work permit. Now, what does this mean for new applications? What if you've never had DACA before? If you've never had DACA before, right now the Immigration Service is not accepting new applications, but stay tuned. There might be some news about that depending on how the Immigration Service decides to change its procedures.
Okay, so if I had DACA and I did not renew my DACA, or I renewed it until the year 2018, can I apply for DACA again?
If you had DACA before, then you can renew it even if it's late, as long as you still qualify. That means you don't have a serious criminal record and that you still remain eligible. You did not leave the United States for a certain period of time. You can submit the application now.
Okay, that's important. And thank you very much for answering that question. So, if you have any questions, please write them down in our Facebook Live. We're transmitting live from Cleveland and Atlanta today. So, if you have any questions, just write them down. And we have a bunch of questions that are coming in through our inbox in Facebook. So, the first question is, I was a victim of assault by another woman. She took me to the police, but I went back against her in the police, and she resulted guilty for the aggression. Can I apply for an U visa through that situation?
Okay, well, a U visa is for people who are victims of certain crimes, who assist the police in their investigation, and who were injured as a victim. So if you were assaulted by a person and you assisted the police, or you did not refuse to assist the police, and the police officer or detective is willing to sign the U visa paperwork, specifically the I-918 Supplement B, then you can apply for the U visa. Okay? Assault is a qualifying crime for the U visa.
Okay, so even if she was not in danger of death, or if this person was not gonna rob or kill, just an aggression at work, uh, I can still apply for a U visa then.
You had to have been injured. So the injury can be physical, like a medical problem, or it could be emotional or psychological. So if you were not physically injured, but you received emotional distress or psychological issues, then I would recommend you see a psychologist or a social worker to talk about that.
Okay, very important. So if you were victim of that kind of crime, please go to the police, talk to them, ask them to sign the form I-918 Supplement B, and then your attorney will be able to help you with your case. And thank you very much, Mr. Frankenstein, for this answer. The phone number is 216 279 3984. 216 279 3984. And please ask your questions live, and we will answer them, or Mr. Francis will answer all of the questions that you have right now through our Facebook Live. One more question that is coming in through our Facebook Live is, um, I came to the United States in the year 2000. I went out because my mom passed away in that year 2001, and I returned just after we buried her. That was a couple weeks later. I have two children that are born in the United States. Can they still apply for me?
Okay, so the big question is, how did you enter the United States and how did you re-enter the United States? If you came into the United States illegally, that means without inspection, then you would not be able to apply for the green card in the United States directly with the Immigration Service, even if you have US citizen children here. Now, there's two ways usually if you have US citizen children to apply for the green card. One way is if the child is over the age of 21, that child could petition for you. A second way is if you are in removal or deportation proceedings and you have a child who is under the age of 21, you could apply for 10-year cancellation, what's called cancellation of removal, with the immigration judge. So the questions are, how old are the children? And how did you come to the United States? Those are very important. Okay.
Okay, thank you very much. And yeah, that's why it's important to talk to an attorney, because they will ask you more questions just to clarify your case and every single situation about your case, and probably get you an immigration relief. So we have another question here. It's Isabel asking, my husband is an expert in countertops and cabinets for the kitchen. He designs them, and he goes to the houses and he builds them. He's right now in Colombia. He doesn't have a tourist visa, but he knows that there are some companies that are interested in his jobs because they have seen what he does. He's not an engineer, but he's a specialist in that matter. Is it needed for him to have a college degree for that, or just by doing that, he can apply for the H-1B visa?
Okay, so this question is about the H-1B. H-1B is for specialty occupations. That means jobs that require at least a bachelor's degree or its equivalent to perform the duties of the job. Usually that means you have to have a bachelor's degree in order to qualify for the H-1B. Now, if you only have experience and that experience is specialized, you could still qualify for the H-1B if you have enough experience. 3 years of experience is equivalent to 1 year of undergraduate education. So that means that 12 years of experience could be equivalent to a US bachelor's degree. Then the question is the job that's being offered a specialty occupation? That means that do you require a higher level education or experience to perform the job? And that's where you should talk to a lawyer to go over the job description and whether that job is complex enough to require a degree or its equivalent.
Okay, that's very interesting. So another person is asking a question related to that, and he says, my friends are from India, and they have told me that I can work for them and that they can apply for a work visa. They have some gas stations in the city. Is that something that we can do to qualify?
Well, there are many types of work visas, but they're for specific categories. Working in a gas station probably is not a specialized occupation, so it probably does not qualify for H-1B. Now, there are other types of visas depending on what country you're from, that you're a citizen of, and what country you were born in. For example, E2. Certain countries, if you're a citizen of certain countries that have a treaty with the United States, you invest in a business, you can apply for an E2 investor visa to come manage that business, okay? Or you might think about permanent residency. The business could sponsor you for the green card instead of a temporary work visa. However, India is severely backlogged right now because of the immigration quotas for green cards. So sponsorship for the green card for somebody from India is going to take probably more than 10 years.
Oh, wow.
Okay.
Wow, that's interesting. Okay, so thank you very much, Mr. Funsang, for this answer. And if you have more questions, please call 216-279-3984, 216-279-3984, and we will be really, really happy to answer every single one of your questions. So more questions coming in through our Facebook Live. Right now, we have this other question. My husband abandoned me and my little girl about a couple years ago, and we would like to know if we could apply for something. He's a U.S. citizen, but we never heard any more about him, and that is devastating for me and especially for my daughter. Is there something we can do?
Well, if you are married to a U.S. citizen and the U.S. citizen spouse abused you, then under the Violence Against Women Act, whether you're a man or a woman, you could self-petition for the green card. So if the U.S. citizen spouse abused you or your child, and you suffered injury, and you're a person of good moral character without a serious criminal record, then you can self-petition for the green card directly with the Immigration Service. That's called an I-360.
Okay, so this person can apply then for this kind of benefit?
Yes, correct. You do not need the assistance of the abuser to apply for this benefit. So you are protected.
Okay, that's perfect. So please give us a call, 216-279-3984, 216-279-3984. Another question here is, I'm living in Ecuador. I got married to a Venezuelan. I am from the United States, but my income is in Ecuador because I teach English lessons in a school. And now I want to go back to the United States, but I want to apply for my wife and her two girls. Do I need to show proof of income, or I need a sponsor because my income here is very, very low compared to the United States income?
Well, when a U.S. citizen sponsors a family member, the U.S. citizen has to submit what's called a Form I-864, Affidavit of Support, to show that the person could support the family member financially. If you don't make enough money, then you can ask a joint sponsor, another U.S. citizen or green card holder, to submit another form, I-864, with your application. If you don't make enough money, or your income is not going to come from a US source, because this income is supposed to continue after you come back to the United States, then you will likely need a joint sponsor.
Okay, so, well, even if they are in Ecuador?
Right. So when you sponsor your family member, your intention is to move back to the United States. So you have to show that your income will continue while you're in the United States. If you're not going to earn enough income in the United States, you will need a joint sponsor who is a US citizen or green card holder who does make enough money.
Okay, very important. And thank you very much for this answer. And thank you very much for the questions. Let's see, we have more questions coming in through our Facebook. So the next question is made by Maritza. And she says, I went to the United States with a tourist visa. I had to return to my country. I never overstayed. If I am a professional, can I apply for any kind of visa?
What country was that from?
She says she is from Mexico.
Mexico. Okay. One question will be, is there a US employer who's willing to offer her a job? And the second question is, if there's no employer, is she going to start her own business in the United States? If a person is going to offer her a job, then she can apply for a TN visa. That is based on the North American Free Trade Agreement, or NAFTA, and is for citizens of Mexico or Canada, as long as the job is a professional type of job. Okay? If she wants to start her own business, then we talked about the E2 earlier, the investor visa. Mexico is on the E2 list. So if she invests a substantial amount of money into a US business, then she can apply for an E2 visa to come manage that business. We usually recommend that the investment be at least 100,000 US dollars.
Perfect. Thank you very much for this answer. And if you have more questions, 216-279-3984, 216-279-3984, and we will be happy to serve your case and to take care of your case in immigration matters. So, well, Mr. Francis, just talking about the asylum and these new rules that we have coming in from the government, what is going to happen with the asylum cases and with the work authorizations?
Okay, so the current administration is talking about changing the rules about who can apply for asylum and be granted asylum. Now, recently, there were announcements about who can apply for the work permit, or EAD, Employment Authorization Document, that's based on the asylum application. Usually, if you apply for asylum and the application has been pending for at least 150 days, you can apply for a work permit while you're waiting for the application to be processed. This new rule, which will start this August 25th, 2020, changes who can apply and qualifies for the work permit. Okay? There are three changes. The first change is if you enter the United States after August 25th of 2020, and you entered illegally without inspection, then you would not be eligible for a work permit.
Okay, that's important.
Number two, if you apply for asylum and you do not apply for asylum within 1 year of coming to the United States, then you would not be eligible for a work permit unless you meet an exception to that 1-year rule. There must have been a reason why you waited so long to apply for asylum. And the third rule is, instead of waiting 150 days after applying for asylum to apply for the work permit, you have to wait 365 days if you submit the work permit after August 25th of this year.
So, Mr. Francis, what is a good reason for a person that did not apply within 1 year?
Well, If you are a minor, then you might not have known about this asylum rule or be expected to know about this rule. So if you are a minor, then the court or the immigration service might excuse the 1 year. Number two, if there was a change in circumstances, whether it's in your home country or in your personal circumstances, where maybe the conditions in your country worsened or something happened within the past year, now you are eligible to apply for asylum, then that's a reason why you waited to apply, because you qualified only recently. Another is if you have lawful status. You don't have reason to apply for asylum until that status has ended. If you apply within a reasonable period after that status has ended, then you can meet an exception also.
Okay, so well, this is very important. So, what if a person is applying for asylum? They miss the 1 year and they want to probably just there's a change in their conditions. They get married to a citizen. Can they withdraw the asylum application and just do the another process in immigration?
It depends on where they are in the asylum process. If you apply for asylum with the Immigration Service, eventually you'll be scheduled for an interview with the Immigration Service. However, if you withdraw your asylum application and you do not have lawful status, then the asylum office might transfer your case to the immigration court because you are now subject to deportation. And they will transfer the case by issuing what's called a notice to appear, or NTA. If you already have a green card application pending based on your marriage to a US citizen, then it's up to the asylum office to decide whether to issue that NTA or not after you withdraw your asylum application. Many asylum offices will not put you into deportation if you have a pending green card application at that time.
Okay, very, very interesting, very important. And thank you very much, because every time you answer these kind of questions in detail, is like a light coming up and just making clear what many people are concerned about. So thank you so much for this answer. And we have more questions, a lot of questions today coming in through our Facebook. So let's see. There's one more question, but just to remind, the phone number is 216-279-3984, 216-279-3984, with offices in Minneapolis, Nashville, New York, Raleigh, North Carolina, Atlanta, Chicago, Cleveland, Columbus, Memphis. Well, a lot of offices in the whole country of the United States. And so we have a questions from one person who is in LA. And this person says that if we are able to help them from the distance.
Yes, of course. Immigration is federal law. That means no matter where you live within the United States, we can help you. If you want to give us a call, or we can communicate through the web or through a chat function, then please get in touch with us, call the phone number, and we can see if we can help.
Okay, that's good. And thank you very much for your time. We have a couple more minutes. And there's a person here that is saying that is in Nashville. Her husband was a victim of abuse by a police officer, and he is from Mexico. Could he apply for an EU visa? It was a very scandalous case in Nashville, Tennessee, 1 month ago. Can he apply for an EU visa? And just counting that it was a police officer, how can we do it?
Well, like we talked about U visas, you have to be a victim of a qualifying crime. So was this police officer charged with a crime that's on the U visa list? Were you assaulted? Were you kidnapped or put under unlawful restraint, the crime has to be on the list. It sounds like you were injured, so there was injury. And then the last thing, is law enforcement willing to sign that I-918 Supplement B? So which law enforcement organization is willing to help you, or are you willing to help for this investigation? It could be the county law enforcement. Maybe it's the FBI or some federal agency. Maybe it's the police department. Are you going to help them in their investigation, and are they willing to sign this form on your behalf?
Okay, thank you very much for this answer. And one more time, you can write your questions live right now, or you can just give us a call, 216-279-3984, 216-279-3984, and we will be happy to answer every single one of your questions. So next question, Gopal is asking, I am on B1 visa and my wife and child on B2. My 6 months are getting over. For extension, do I have to file myself as B1 in the form as my I-94 shows that, and for my wife and child B2 as it shows? Do you want me to read the question again? Because
no, I understand.
Okay,
I understand.
Okay, perfect.
Okay, so because of the virus, the pandemic situation right now, a lot of countries are not accepting people who are from the United States back into their country. There might not be flights available, and flights are being canceled left and right. So if you are nearing the end of lawful status, your I-94, you might need to extend your B1 or B2 just to make sure you're not overstaying your visa. Now, if you are in the United States on a B1, which is a business visitor, and your spouse and child are on B2, which is a tourist, then I would recommend you file 2 separate applications. One for yourself to extend your B1, that's on Form I-539, and a separate Form I-539 for your wife and the child. So 2 separate applications, because you don't want to combine everybody on one application and the Immigration Service in the end denies for one of the 2 of you because you did not follow the proper procedure. And then you would overstay your visa.
Oh, okay. That's very important. It's very bad if we overstay our visa even during this pandemic?
Well, when you overstay your visa, technically that means that your visa stamp, it could be a 10-year tourist visa, that is revoked. That means you have to go back to the embassy to apply for a new visa. Now, because of this pandemic, the embassy might understand and say, okay, we will let you apply for a new visa even though you overstayed, but they have the discretion to deny your visa because of that overstay. So you want to limit your immigration problems. So it's always better to maintain your legal status, file the extension just in case.
How many days before the expiration of the I-94 should we file?
As long as the Immigration Service receives your application by that expiration date, you are fine. Now, I would not wait till the last minute, because if you submit the form without the proper paperwork or without the proper fee, or you send it to the incorrect immigration address, the Immigration Service might reject the application, and then you might have to refile too late. So submit the application maybe 1 to 2 weeks before the I-94 expiration date, just to be safe.
Okay, that's perfect. And well, just one last comment before we dismiss today. So there's a lot going on about DACA, about the student's visa as well. And I would like to dismiss talking about this student's visa because there was a lot of changes in the last 1 week or 3 or 4 days. So what is the final decision about the student's visa?
Well, because of the pandemic, many schools and colleges have transitioned to online-only classes to protect the students and the staff at the schools. Some schools are talking about having a hybrid model. That means a mix of online classes and in-person classes to limit the number of people on campus at a certain time. Now, ICE, the Immigration and Customs Enforcement, which oversees student rules, previously said that any student who is going to a school that only has online courses, that student will not be able to remain in the United States because of online courses only. That student would either have to leave the United States or transfer to another school that does not have online-only courses. Now, that policy was changed within the past 2 days. The ICE worked on an arrangement with schools and states to say that they're withdrawing that new policy. Now, we do not know if ICE will revert back to the previous policy, which allows students freedom as long as they are attending classes, whether online or not. But we'll just have to wait and see what happens in the next few weeks as schools make their plans for reopening so that students can be prepared.
Okay, well, we hope there's a positive answer for all these people that are applying for a student visa. And we know that it's a political year, it's an election year, and there are going to be a lot of changes, a lot of discussion about everything that's going on. So we hope there is something positive coming our way in the immigration matters. And hopefully, if people need an answer for them in their immigration cases, we're going to have, of course, Mr. Francis Fungsang, Joseph Fungsang, Alison Chan, Fabiola Cini, Richard Drucker, Jonathan Bartel, Jennifer, I forget her name right now, Jordan, and of course, Miss Margaret Wong, who was not in the show today with us because she's on the road. Usually she flies, but for safety, she's not flying now because we know it's a big problem getting on a plane right now, especially at certain age. So we love Miss Wong. We miss her, but of course, Mr. Fungsang, you did an awesome job today, and we know you are one of those doctrinaries, could I say, or one of those experts that we have in the law firm, and you even advise Ms. Wong for any questions that she may have in a case. So thank you very much for your time, for your answers, and looking forward to have you again.
All right, thank you, Juan Carlos. I hope I was helpful.
No, it was very, very helpful. And for everyone, everyone who is connected with us today, thank you very much. Don't forget these phone numbers, 216-279-3984. And if you have any questions, just give us a call and get connected next Thursday at 12:30. That we are going to be answering every single one of your questions. Thank you very much, and see you next time.